Is this on, you guys? Yeah, okay, good. Hi, everybody. Welcome, Ed. Welcome, everyone, to tonight's lecture, which is the 19th annual Myriam Bellazoug Memorial Lecture. And for those of you worried about studio work, the final lecture of the semester. And before I turn the podium over to Professor Easterling, who will introduce this evening's speaker, I just want to say a few words about the Bellazoug Lecture series. This is somewhat emotional for me, in fact, because I knew Myriam. But this series of lectures was established in 1999 to honor Myriam Bellazoug, a 1991 graduate of the school who was killed in 1996 when TWA's Flight 100 mysteriously crashed after taking off from JFK. Myriam was then editing what would have been Perspecta 30, and she was flying to Paris as part of her work in the office of the architect Peter Marino. He gave funds that help endow this lecture series. So in honor of Myriam is one of the reasons of the tight connection of the lecture to Perspecta. And the idea was that the editors of the most recent Perspecta be given an opportunity to invite a contributor to their edition of Perspecta to deliver a public lecture on an original topic. The Bellazoug series was inaugurated with a talk given by Mark Wigley, and subsequent lecturers have included Michael Hayes, Kenneth Frampton, Felicity Scott, Neil Denari, and the most recent lecturer was Saskia Sassen, who's a professor of sociology at Columbia. Tonight, Sergio Muñoz Sarmiento, I don't think I did that justice, my apologies, joins us at the invitation of the editors of Perspecta 49, titled Quote. AJ Artemal, Russell Lesturgeon, you're all here, right? And Violette de la Salle, all 2014 graduates of our school. So welcome you guys, and thank you for inviting Sergio. And now, Keller, I welcome you up here.
Thank you, and I'm so pleased to introduce Sergio Sarmiento this evening, who was chosen by the editors, AJ and Violetta and Russell, as the Myriam Bellazoug Lecturer. Sergio holds a law degree from Cornell Law School, as well as an MFA from California Institute of the Arts. He has a law office and also runs the Art and Law program, which is a think tank with a theoretical and philosophical focus on the effects of law and jurisprudence on cultural production and reception. And the program accepts fellows for a spring and fall semester. This year, the fall term is operating out of SVA in New York City. And the Art and Law program encourages a fresh strain of critical thinking about aesthetic, cultural, and intellectual practices. And I've really enjoyed the times I've joined this group for conversations that range over a whole spectrum of issues, including, I'll quote from the program description, territoriality in space, law as medium, tangible and intangible property, language and contracts, moral rights and authorship, and sovereignty and international law. So it's an amazing program. Sergio's been published in articles or interviews about the intersection of art and law in places like Cabinet, Hyperallergic, Harvard Journal of the Legal Left, as well as tons of catalog essays. He's taken part in public debates and conferences sponsored by Triple Canopy or the New York Times, among many others. I first learned about his work, and maybe it was the same time that the editors of Perspecta went on a panel with him at Yale's Legal Medium Conference. It was an interdisciplinary conference over at the law school that brought together artists and legal political thinkers from around the world. And what was so intriguing about was the prospect of kind of applying Sergio's super clear analysis to not only art, but also architecture, especially as our discipline tries to assert another kind of authority in cultural political decision-making. Tonight's lecture will surely make a legal landscape more palpable for architects in relation to property, among other things, while also gesturing to some of the spatial political consequences of questioning those legal structures. The editors of Perspect to Quote did something very nice in the design. They kind of pulled an epigraphic quote and printed on a single page for all the authors in the issue. And Sergio's quote is a great one. I'll read it. He writes, if there is a quintessential discourse of power, it is law. And if there is a quintessential manifestation of power, it is architecture. Please welcome Sergio Sarmiento.
So I'm going to silence my phone, but I'm also going to take a picture because this might sound cliche, but my mother still doesn't believe I do this. She says, she still thinks I graffiti walls. And I said, you know, Mom, I am giving a talk at Yale. And she says, I knew it. I knew it. She says, I knew eventually you would end up in jail. So now I can relax a little that the photos are done. I usually don't dress like this. You can ask my fiance. I usually wear a Metallica or a Ozzy t-shirt. But anyhow, where the hell am I? Like, I walked into this place. You know, like, am I gonna be allowed to walk out? So I want to thank you all for coming to this talk and for the invitation, Dean Burke, Russell, AJ, Violet, Richard, thank you for all of your help, because I'm particularly excited about this talk because it's the first time that I can share my thoughts with an architectural audience. Primarily, I speak to legal scholars, artists, art historians, and so forth. And so I'm hoping to get some fresh feedback, even if it's in silence. And by the way, on my drive up here, I noticed some billboards by Dutch's, which I guess is a fast food place. And one of them particularly stuck out for me, and it said, serving you fresh chicken, which is what chicken really is. And I thought, what? Right? If you're a semiotician, like that's just that's a doctoral degree right there. Anyhow, I want to begin by sharing a personal conversation I had recently with a good friend of mine who also happens to be a commercial litigator. During a debate over intellectual property and the internet, my good friend Elaine said this to me. And we all know that when something becomes sufficiently arcane and the province of a small group of people, the existing structures tend to be reified and made more arcane to protect the priesthood rather than challenged. Elaine Golan. This brief but poignant thought neatly summarizes what has preoccupied me for the past couple of years, the question of what is law. This got me thinking, how do we begin to understand this thing called law, particularly for those of us invested in modes of cultural production, be they architectural or artistic? You see, for me, art has always occupied a special space. It's the space that some of us go to when we are not comfortable operating in those spaces governed by strict definitions and predetermined ways of being. It is where some of us go to when we do not yet know what to call that we are doing. To be clear, when I say art, I mean all forms of cultural production, including, of course, architecture. To me, as I'm sure as it is for quite a few of you, architecture goes beyond the design and making of buildings. Given my talk and our context tonight, we can begin by asking two easy questions. What is law in relation to architecture? And what are some of the ways in which law impacts architecture? One, law dictates the size of doors and windows. It also dictates who must have access to these doors. It dictates how we get out of a building in case of a fire. Law impacts the process you must go through to obtain an architectural license. It impacts who's liable on a construction site and who's liable for damages caused by a faulty design. Law also allows us to discriminate who we want to sell our home to, so long as it is not based on certain factors. Law dictates when homeowners can be forced to relocate. Law facilitates oral and written agreements between private parties, such as commissioning agreements. And law impacts who owns the intellectual property to your designs and buildings, and so on. And so we can say that we already know this, that these rules are rules that we must follow if we want to be professionals and make things called buildings. But what if we question these rules and regulations? What if we found ways to think otherwise? I propose, however, that before we even begin to question this arcane space called law and the priesthood that weaves and perpetuates it, we must first know the law. And by this I mean understand what this animal looks like. Its form, how it moves, how it fights, how it reproduces, how it learns, how it sleeps, and whether or not this animal even dies. I believe we can begin to know this animal by thinking about this dictum: law ends in a non-hierarchical space. I still have to give this theory of mine a bit more thought, but I feel comfortable stating that there are at least 3 structural ways in which we can begin to understand law ends. 1, methodology; 2, margins; and 3, finality. I will try to explain each one. We can think of law ends in terms of methodologies, where the ends justify the means. Law has a purpose. It is teleological. Law allows us to get along as best as we can. It provides us with reliability and consistency. It provides us with an answer, however unsatisfactory. It allows us to avoid traffic jams and endless debates over political elections. Methodology is the easiest to understand, given that that is precisely what we have now: law as a social construct for the sake of fulfilling an unbargained for social contract. We are born into this methodology. In a sense, we inherit it. We can also think of it in terms of margins, as the most extreme part of the law, as the outer limits of law. How does the law allow us to overcome, ignore, and exploit ethical mandates? What are the gray areas of law? How far can the law go before seeming unlawful? To what extent can we incite imminent lawless action? Brandenburg v. United States. And how far can the law go before seeming unlawful? To what extent can we and how far can law go, to what extent, to serve what purpose? To serve whose purpose and whose good? When can U.S. citizens be rounded up and put in internment camps under the guise of national security? Korematsu v. United States. What would these margins of law look like? How would we visualize these margins? Would these margins be singular or plural? How high can you build? How deep can you dig? Who has access to institutions? And when can a foreign national, a teenager playing amongst concrete columns, be killed so long as he is not on American soil? Hernandez v. Mesa. And are these margins of law moral, ethical, and/or pragmatic? Or do we momentarily, provisionally, or perhaps even eternally forget about all moral and ethical concerns in search of and for the purpose of survival, in search of the new and the radical? And finally, we can also think of law ends in terms of finality, the conclusion of law, the end of law, the death of law. I believe that these three structures are interrelated and not necessarily mutually exclusive. Given our limited amount of time, I want to focus on the finality of law. And I want to begin by posing a question for tonight. What would a world without the law look like, however provisional and however temporary? Now, I don't want this question to sound moronic and irresponsible. Rather, I ask this question in hopes of starting to think about a space where law as we know it is non-existent and unnecessary, or perhaps simply not applicable to me or even to us. This is not to say that interrelations are also jettisoned. Quite the contrary. Can we coexist in a space that is outside of the parameters of what we have come to understand and what has been foisted upon us as the law? In order to understand why I would even pose this question, I believe it's important for me to share an art project with you that led me down this rabbit hole. In early 2000, I became tired of the same old critical theory, the same old postmodernism, post-colonialism, post-everything being trafficked so readily in academia. As luck would have it, my girlfriend at the time was applying to law schools. I'm not so sure I was lucky then, but I became fascinated by the application catalogs that she received. I began to read through them, and as soon as I realized, after seeing courses such as "There's no such thing as freedom of speech," that this was a space that could provide me with ways of thinking about language, justice, and power different than those I had been exposed to. Although law school was the farthest thing from my mind, it quickly became apparent to me that the only way I could fathom doing something so seemingly stupid was to do it as an art project. In 2003, I applied to 15 law schools. I studied and took the law school admission test. I was accepted to a few schools. I attended Cornell Law School. I graduated law school. And I took the bar exam and became licensed to practice in the state of New York. This entire process was documented via photos, video, and text. Now, as a side note, I have to say that up until this point, my mother was very pleased and very happy that her boy, once an artist, had finally mended his errant ways and was well on his way to becoming a corporate lawyer. Well, her dream didn't last very long. Anyhow, why did I do this? Why did I do the Cornell Law School project? Because I realized that if I truly wanted to understand law, power, language, I would have to go to the space where these things fermented, where these things were constructed. I would have to go to that arcane space that the crazy few access, kind of like Star Trek, to go where no person has gone before. What I did not expect to happen happened. The power and institution of law seemed overwhelming. Similar to Nietzsche's proclamation, which I noted earlier, "Battle not with monsters, lest ye become a monster. For if you gaze into the abyss gazes back into you." Initially, I had been able to objectify the project to acknowledge why I was really there. But inexplicably, I began to notice that I was becoming, or had become, just another law student, competitive, argumentative, competitive, and argumentative, and repetitive. Ultimately, a complete transformation did not happen. I would like to think that it was the power of art that kept me and has kept me from becoming 100% one of them. I am often told, and I think somewhat pejoratively, that I speak like a lawyer, that I think like a lawyer, that I act like a lawyer. But I would rather say that I speak, think, and act that way because I have learned, and am learning, how to mimic that animal. Increasingly, I have become more interested in expunging the visual from this project and focusing more and more on the textual and oral recounting of it. There is something about having to recollect the law school project through memory, to have those years constantly reinterpreted and recounted through the lens of current experiences. I should note the caption of the image I had on the lower left-hand side of the image, "Some law school library." Interestingly, as a side note, if one Googles law school library, one pretty much gets images of what appears to be the same style, the same interior, exterior of a building, the same stones and the same arches, the same stacks, the same open piles of books on the same tables that now, due to the internet, no one reads, the same scales of justice, and the same paintings of the same subjects. Clearly, law has a fascination with the monotonous, the predictable, the historic, and the exclusive. When I think about my initial encounter with the study of law, I have come to the conclusion that it ultimately would not have mattered which school I attended. The more time I spent thinking about law and culture, the more I believe that all law schools would have taught me the same way and the same things, the same way of thinking, being, and doing. I learned a couple of valuable lessons in law school, though. One lesson, the main lesson, and this I thank law school for, is that at its core, in the most fundamental sense, law is, by definition, fiction. Pure and simple fiction. It is man-made, and I do use that term intentionally. It is a product of make-believe, but a make-believe that makes itself relevant through force in many formats of violence. At some point during my time in law school, I began to visualize, in color, the legal doctrines taught to me: contracts, property, torts, criminal law, constitutional law, employment law, and so on. Lines would connect and interconnect. People with street signs, people with people, vehicles with buildings, trees with electrical wires. The other vital lesson law school taught me is that it is not the answer to the questions that matters. It is how you frame the question that matters. For how you frame the question is a powerful tool in obtaining the answer you want. It is a political weapon. Using this weapon from law school, let's reframe the question, what is law, to what are the structures of law? One way to think of structures of law would be the culture of law. The law is a fetish. Television, films, plays, novels, music about law and lawyers. But not all representations of law are necessarily bad. And here I think about a recent television shows such as The Walking Dead, Sons of Anarchy, and Breaking Bad, all of which signal a realization by individuals and groups that law as we know it has failed. Another structure is the pedagogy of law, the educators of law, the professoriate, the legal scholars who study, research, and write about law, and law students. There are also the attorneys who practice law, the judges who apply it, those who follow the law, those who break the law, this lecture itself, which both perpetuates the importance of the law, but also attempts to demystify what the law is. And of course, the architecture of law, the buildings where law takes place. Another way to approach this question is to think of the Richard Rogers interview in the latest Perspective, where the editors invite us to think of architecture not as a formal statement, nor necessarily as a building itself, but rather as a design for a pattern of behavior. So if architecture is a design for a pattern of behavior, can we not also say that law is similarly a design for a pattern of behavior? That both can and do foist their power upon us in order to force us to act or not act in a certain way. For example, a contractual agreement is like a building. It's like a city, like an urban plan, like space. It is the outcome of negotiations. It is about structuring how we get along, how we navigate space, and how we relate. And perniciously, as with some buildings and spaces, there are contractual agreements that are not negotiated, that are not mutual understandings. Furthermore, like some buildings and cities, not all contractual agreements function to the best of their ability. In this Perspective interview, Rogers argues that architecture operates for two clients: the user, who is primarily concerned with the function of the building, and the passerby, attuned to the building's larger role. For Rogers, this means buildings that communicate their role to the public and engage with a larger context. Apropos to our conversation today, Rogers cites court buildings as schools for understanding what is right and what is wrong. Now, interestingly, Rogers calls them buildings and not houses. Rogers' proposition regarding court buildings as schools for understanding what is right and what is wrong lends itself to multiple interpretations. One, and the most obvious, is that in these buildings, we lend ourselves to the judgment of others. That these buildings house those who assess our actions and non-actions as being right or wrong according to the laws which we believe we have promulgated. Second interpretation, that these buildings function as schools where jurors, judges, and attorneys practice, learn, develop, and perpetuate what they have been taught and thus believe to be right and wrong. This would seem to indicate that we, plaintiffs, defendants, witnesses, the accused, victims, are all but props, guinea pigs in an absurd theater of law. Third interpretation, that these buildings should have us question the materialized representation of what is right and what is wrong. In other words, that perhaps the mere existence of these buildings and what they symbolize is wrong. The existence of these types and styles of buildings as representative of our so-called democratic ideals is wrong, or perhaps simply outdated. Here are two examples. This is Saul LeWitt in the U.S. Courthouse in Springfield, Massachusetts. Ellsworth Kelly, U.S. Courthouse in Boston, Massachusetts. Now, what is a criminal defendant supposed to think when they walk by these artworks? Geez, I have just been convicted for a crime I did not commit, and I have been sentenced to prison for life, but hey, that's one great Saul LeWitt. I'll take that as a moment to take a drink. That actually did run through my mind. I've been in the Boston courthouse. So why are these courthouses in Massachusetts adorned with abstract art? Well, here's another interesting example. This is an Orozco mural from 1941 located at the entrance of the Supreme Court of Mexico. And if you notice, the reason I picked these slides is so I can use my little indicator here. Here's Lady Justice here and here. But if you notice, here, right? It's kind of like passed out asleep, not really paying attention. They're masked. Then you have these two they're either judges or they're lawyers, and it's complete chaos. And this is at the entrance of the Mexico Supreme Court. And the only reason they won't take it down is because of the amount of protests and controversy it would cause. Seemingly, that's the only reason why. Developed a bit further, why have we relied so heavily, and why do we continue to rely so heavily on modes of thought that are archaic and that do not lend themselves to openness, transparency, criticism, conversation, and change? Perhaps one way is to use these same laws for one's own purposes, to use the principles underlying law for another purpose, another sake. I will now share with you an action of mine that I have never considered to be artistic, sculptural, architectural, or performative. Now, I want to apologize for these slides, these images, because they were very crudely transferred from slides themselves, analog, to a digital image. In the year of 2000, I looked for and found what appeared to be an empty lot in West Texas. This site was only accessible via a dirt road. My intent was to find a site that was not mapped and to install a structure that would elicit an aesthetic experience, but only to those that would happen to stumble upon it. So it was way in the hell out in the desert in West Texas, very hard to reach. I proceeded to install playground equipment on this site, a swing set, a slide, and a half-moon aluminum structure, without the knowledge or consent of anyone who might have had a claim to this land. I wanted to make a gesture that would most likely have a small audience and little to no impact outside of its own presence. In 2001, exactly 1 year later, I returned to this same site and found that a local community had formed around this playground, building a fence around the playground out of wooden posts, cable wire, and discarded rubber tires. This playground now had an entrance gate. The playground had been appropriated. It had been embraced. So originally it was just the half moon, the slide, and the playground equipment. And if you can kind of tell, these are all tires sunk into the ground, some wooden posts, and then this gate, which, I mean, you guys know better than I do. Is it functional? I mean, I guess it's functional, but you can just walk over the tires. But it's very charming. So that project made me realize that what I was doing was appropriating someone else's property as a medium, no different than appropriating images, text, sound, or moving images. I wondered what exactly made this piece of land someone else's and not mine. I did not know it then, but what was in fact happening was that it was a simple piece of paper that granted, through a legal fiction, property rights to one person and not to the other. This piece of paper is called a deed, but in art speak, it is called a certificate of authenticity. Taking this idea of claiming someone else's property as mine, I began this project, A Question of Property. This project took place in East Los Angeles. The nature of this project translated to me no longer installing any physical elements on a site. Rather, and in a Duchampian manner, I instead opted to simply index this particular wooden armature, and only the wooden armature, as a sculptural artwork created by me. As we know, there is no art exhibition without an exhibition announcement. Thus, an exhibition announcement for this project was created, they were sent out to the general public, and they indicated the location of my sculptural work, the dates of the exhibition, which were based on the amount of time that the raw wooden armature would be visible to the general public, and the hours the exhibition would be accessible to the public, in this case, 24 hours a day. Now, I did note that unless there was an added element to this project ran the risk of coming off as too simplistic and juvenile. So the added element was that I drafted, with my pre-law school ignorance of law, I still have some ignorance of law, a certificate of authenticity guaranteeing the originality and authenticity of this project, naming the wooden armature as an artwork. Among other things, the certificate gave the owner of the project, for life, the sole aesthetic property right in the wooden armature, to include but not limited to aesthetic appreciation, aesthetic experience, spectral presence of the armature, and visitation rights. The certificate also made clear that should this project ever be included in any exhibition, at no time should the wooden armature ever be rebuilt. Rather, the location of the sculptural work would have to be indexed, and any viewing audience would have to travel to its exact location to experience its spectral ghost-like form, the actual project. In effect, the armature will always be there, but not visibly there. Interestingly, 2 certificates were sold to 2 different collectors, one for this structure and one for this structure, entitled Assigned Value, which this one was in West Texas. This project had all the similar aspects of my previous one, with one small caveat. Realizing that I was capitalizing off of the unacknowledged labor of migrant laborers, I decided to, 1, credit the 3-man construction crew that was present during my photo documentation of the project as co-artists of this project, and 2, that I would have to share with these same 3 migrant workers any monies made from the sale of the certificate of authenticity to this project. And thus, the $10,000 amount was split 4 ways, equaling $2,500 each. My co-artists are Alejandro Sanchez, Miguel Espinoza, and Roberto Alcala. Now, this was really funny because they were living in Juarez, Mexico at the time, and so I obtained their addresses. And you can imagine, I go knock on their door, I walk in, I'm having a Mexican Coca-Cola, And I present them with an envelope with $2,500, and they said, "What's this for?" And I said, "Well, it's for your artwork." And they said, "What artwork?" And I said, "This artwork." And it was a very interesting conversation about aesthetics, because when you talk to construction crews, they have a lot of pride in the labor that they do, the installation of the wood, the nails, the sizing, the measuring. So they were a bit taken aback. They didn't say no to the money. They were just taken a bit aback. Now, I'm going to wind down the talk because I want to take some questions, but I'd like to wind down the talk with some very quick non-art references that have inspired me in my ongoing research of property, art, and law. In 1823, the United States Supreme Court ruled that Native Americans did not own title to their land, deciding instead that settlers trespassing onto Native American land obtained title to this same untitled land due to their discovery of it. What's interesting about this case, Johnson v. McIntosh, is two things. One, it establishes property rights by discovery. The other interesting thing about this case, it's a Supreme Court case that has no precedence. If you read it, when I teach it, both with my law students and artists, it's fascinating for them to note that there are no citations. There are no other cases cited. And this is one of the fundamental cases of property in this country that is pure and complete fiction. Where does that law come from? Now, as a side note, my first year of law school taking property law, my law professor said, read the following cases and skip the first one. Now, when you tell nerds to skip something, I'm in a room, no offense, but very smart nerds. What are you going to do? You're going to read that. And a friend of mine and I, of course, were very astonished, and we asked her in class, said, why did we skip this case? She says, well, I didn't think it was that important. Similarly, the eviction under eminent domain of a thriving Mexican-American community from a space that was called Chavez Ravine in order to build what is now the LA Dodgers baseball stadium. I stated earlier that law is fiction, and no other legal doctrine better illustrates this dictum than the law of property. To ask what is law is reminiscent of Heidegger's question, what is thinking? Where we reach an impasse because we cannot think thinking without using the tool known as thinking. Does this mean that we need another tool, another way to think about thinking? Similarly, if law is in part language, can we even ask what is law and begin to understand it through language? Can we ask what is law without using the tools that allow law to exist and that law itself allows to exist? Perhaps this is where the notion of the outlaw comes in, which means to take the position that one need not bother with asking what is law, because the outlaw begins from the premise that there is no law. No law means being in ways still uncoded, unregulated, unhinged, unknown, and unaccepted. No law is the law. Thank you.
You said you were willing to answer questions, so do we have questions?
Sure.
All right. Is it good? Yeah? Okay. Thanks very much for your talk. I think it's particularly interesting considering that the circus that we all know as Art Basel is now underway in Florida, which is in a lot of ways the interaction between art making and this larger system that we all live in. You said that law is by definition a fiction, and I got from your talk that you consider this the fiction that explicitly defines the rules of civil society, while cultural production, on the other hand, is a method of implicit civil control. Can you highlight some ways in which these two forces could work together, either can, should, or shouldn't work together going forward in sort of this new America now that we're living in?
I want to make sure that I understand your question. Can you rephrase or restate the last part?
In sort of how these
After Art Basel. I
after
got
the
caught
whole,
up
the
on
whole
Art
question.
Basel.
Then, yeah. Okay.
I'm just surprised someone would actually raise Art Basel today, but that's great.
That was more an aside, I guess, that may have derailed us. Just saying that law is the fiction that's in explicit control of the way that we interact, while
Sure.
cultural production is sort of an implicit control of the way that we interact in society, or
Yeah.
is seen as that, and how these forces can, should, or shouldn't work together.
No, that's a phenomenal question. And, in fact, I get very close to quitting what I'm doing practice-wise as an attorney. Because one of the things that I've noticed in the so-called art institutions is that the first thing they do, I get called first. In terms of liability, what are my liabilities on the institutional side? Artists, how do I become an unlimited liability company? How do I incorporate? How do I make sure that we get the insurance? What's happened is that the art world now is mimicking that animal called corporate law, right? And artists are functioning increasingly like corporations. In every which way, which is to me a bit disturbing, because the reason I do this is because I don't want to be that animal, right? And this is also being perpetuated in art schools, where the only way to function as an artist is the market. And what goes along with the market is commerce. And if you're in commerce, you're a business. And I don't know if you're familiar with the recent case with Peter Doig, where it's the first time that I think that we know as lawyers where an artist had to testify that he did not make an artwork. Living artist, obviously. And why is that? People were all freaked out in the art world. It's like, this is what you breed, this is what you get. Why? If you're going to be a business, you're no different than McDonald's. You're going to have to serve a certain type of food, a certain type of drink. It has to be regulated, it has to be coded. You're susceptible to lawsuits. So where now I have to advise my art clients to say and to think, you're running a business, so a percentage of your income has to be allocated not only to accountants, but attorney's fees. That's not an artist. And that to me it is. Is that kind of where you're going? Yeah. And there was I'll say this last thing, there was an art fair last weekend in New York, alternative art schools, and we participated. And what's interesting about that is that I think artists or people who want to do this thing called art are looking for places where they can learn from others without this administrative bureaucratic institution called art school. And law schools are not much better, to be honest with you. That was doom and gloom, right? Yes. Do you want my microphone?
While you were going through law school, I have so many questions about what that was like for you and what that was like for your colleagues, but not in relationship to law versus art, but clearly with your critical theory background, which you're trying to get beyond, but there's a critique of capitalism in that. And so I'm just curious what you, as a critic of capitalism, experienced in law school and how complicit you found those two things to be, and your opportunity to open up discourse at Cornell around that issue.
That's another great question. In my torts class, which are wrongs against a person or property, there was the case book's about this thick, and there was a little snippet on one law professor from UCLA who cited Marx. And so when I read that snippet, I went to the law library and I got these books on Marxism and law. And I went to see my torts professor and I said, I want to talk about Marx. He says, don't waste your time with that shit. He said, quote unquote. He said that to me and he says, learn the law. 3 years. Once you're out, you can do whatever you want. And at that time, I was really frustrated
But then I realized that was the best advice I had ever gotten, because that's what I was there for, right? To see and to study that beast, not the one that I was already coming in to this space with. And, you know, I remember sitting in constitutional law class and looking at the space and thinking in Derridian terms. I know exactly what's going on here, right? And at some point, I don't know when it happened, like psychologically, mentally, intellectually, I became the other. And I don't know what ruptured that mode of thought. But, you know, on a funny side, I remember the dean did call me in because I had told my best friend that this was an art project, and I said, don't say anything. So the dean calls me in, and he, you know, it was very nice, very, very lawyerly, said, you know, what's going on? You know, I heard this is a joke to you, and I said, it's not a pretty sadistic joke, or masochistic in this case. And I said, it's not a joke. And it was the second semester, so the first grade semesters were already in. I was nowhere near the top 10%. But I did pretty well, I have to say, for being an artist. And so I said, you know, and I said, look at my grades. And he says, yeah. He's like, I guess you're okay. He's like, well, look, as long as you don't screw the curve. That's what he was worried about. Of course.
Thank you very much. I think I can see a connection between architecture as fiction, as fiction, and the idea that you would have intellectual property rights over your design. If law is a fiction, can an individual have intellectual property rights over an act of law?
Over an act of law. What comes immediately to mind, or I believe it's the state of Georgia, who has now hired a research data bank similar to Westlaw and Lexis to annotate Georgia state law. It's a private entity. And the fear is, what this corporation has said is that it owns the intellectual property rights to Georgia state law. And of course, the fear is that eventually, if you're a citizen or a resident of the state, that you would have to pay to have access to the laws of the state of Georgia. So that's what comes immediately to mind. On another note are Westlaw and Lexis, who have argued that they own, and they do own actually intellectual property law to their intellectual property to the way they format legal cases and opinions, legal journals, and so forth. And thirdly, attorneys themselves have argued that when they draft anything from a cease and desist letter, a demand letter, an opinion, an amicus brief, that they also own the intellectual property rights to those documents. And so the other interesting way of controlling the rights to documents that I believe should be made open to the public are settlement agreements. Because the theory is that the public doesn't know, if you and I had a dispute, how we settled, what amounts. So there's no way that a third party can ever assess, should they have a similar situation, under what bandwidth a good settlement range is. Is that something that, is that what you had in mind, or?
It just seems that there's, if you think of law as something that is a public good, if that makes sense, then I presume there is an analogous argument against the very idea of intellectual property rights over architecture if the architecture is good.
Is a public good? Well, the question is, that's the question, right? Whether, what would we consider to be a public good? And what is that public good? Right? On the one hand, if you look at the copyright, it's a constitutional right. And to paraphrase the statute, the language, it's to incentivize the production of culture. And what that says is that you get limited, the intellectual property rights are granted to the author for a limited set of time, which is now 70 years after death. And the other argument is, well, the limitation period says after a certain period, it should become a public good, enter the public domain. And you know, architectural buildings themselves in the United States don't get copyright protection until 1990. It's not that old.
I would invite you to go to the New Haven Criminal Courthouse. When you walk up the steps, the image on that mural on that wall is an individual down on his knees rolling dice with death, which is even better than the one you...
With Ellsworth Kelly or Saul
No,
LeWitt?
it's a 19th century painting. You hinted at this a little bit, and I, you know, maybe it's a longer conversation because this one interests me a lot, and I've thought about this for a long time. But there is, let's say, I would say I bring the New Haven anecdote up because I think it's always understood, at least in legal theory, it's no surprise to say that the law is a fiction, that it has no stable ground, that it is always, if one understands it, it is always negotiable, it is not fixed in any way. Yet architecture, or the architecture of the courthouse, I thought you had claimed, is in some kind of contractual relationship to make that seem permanent, although the Supreme Court is a more interesting building, I realized when I was looking at it, that it's several rows of columns before it's an enclosure, so it's never quite permanent. And the works you showed that were architectural were scaffolds rather than permanent or fixed structures. So they're both disciplines of representation primarily. And architecture has always seemed to be the one that is permanent, and when the law is seen as permanent, it has an architecture and a foundation. Do you think there are problematics relative to the discipline of architecture that you're interested, as opposed to, I don't know what art means at the end of the day, because it's so broad-based, but architecture does have a cultural contract in that way.
Yeah.
And I wonder if you've examined that, because you hinted at it, that it is in the representative courthouses themselves.
You know, one of the reasons what excited me 3 years ago when Russell, AJ, and Violet reached out was that it forced me to ask that question or to deal with these thoughts that you're bringing up in relation to architecture. And I'm just at the tip of the iceberg. It's really fascinating. But I'll say two things. One is, I don't think law is fiction is that obvious. Otherwise, people wouldn't just mindlessly follow it, right? I mean, and for example, because this is the film of the season, the holiday season, Loving, the film Loving, which is based on the Supreme Court case Loving v. Virginia of 1967. So that's 47 years ago, I believe, roughly, right? It's when the Supreme Court said that banning and criminalizing interracial marriages was unconstitutional. And if you think that's 47, it took almost another 50 years for the Supreme Court to say that gay marriage was constitutional, right? So there is that same type of permanence that you're talking about. You know, I was given the tour, and you know, when you look at oh, I didn't know that. Did someone shut? Okay. Oh, I saw it. Now it makes sense. So as I was given the tour today, you know, I'm looking at these reliefs and these sculptural pieces in this building, and I thought, wow, that's no different than when we see these in law school. I mean, you know, I'm not here to like diss your house. That's the last thing I'm gonna do. I'm not gonna get fed. Right? But there's an element of propriety, right? There's that sense of propriety, which is property. And the question is, who has access to, what does that property mean? Which is what the gentleman right behind you was asking, right? Is it a piece of paper? Or is it a contract between the state of Georgia and a private corporation? Exactly, right? So the law is fiction. I think there we might have a bit of a disagreement. But in terms of its permanence, I think I am just beginning to understand this for myself, right? Like why, you know, I have my art students ask me, you know, what's this electoral college thing? Like, why do we have, can't we file a class action lawsuit against Trump? You know? And aside from like how ridiculous that sounds, it's not understanding that what they're really attacking is, you know, they're graffitiing the wall. The structure is going to remain there. You're looking.
The structure always remains, and there's other things we've seen ornamental to that structure. So that contract seems incredibly important culturally, because that question of property is fundamental.
Sure. You know, David Mamet, one of my favorite. David Mamet or property? Sure. And to me, it's property law. Without property law, Bentham says this, there is no law. Without law, there is no property. But David Mamet actually wrote about this a few years back when he said, you know, the reason we have a constitution, the U.S. Constitution, is because people are fundamentally evil. Yeah.
So, I mean, the two Texas projects that you showed are so tantalizing because there's this big, wooden, hot, bulky, dusty thing out there that's inflected by this piece of paper, you know. And for us as architects, we know that there is law that's making architecture dance, that's making, you know, that's changing, you know, acres of space every day. We're not manipulating that, but I'm wondering if you have examples that you might want to talk about from the art and law program where some of the artists or other thinkers are using a tool of law to inflect something hot and bulky and dusty, or to make something hot and bulky and dusty occur.
You know, one project, thinking spatially, that comes to mind is it was the third class, I believe, in Michael Cataldi, and he was asked to do a project at the Sculpture Center in New York. And what he decided to do was to take the air rights of the Sculpture Center. And the only way he would do the project is if the board of directors assigned him the rights, legal rights to those air rights for a period of time. And you can imagine at first they said, no way, we would air rights in New York. And we convinced them to do it for a number of hours. Right? But to me, that was a huge victory because even that number, all you need is a minute. I think the most expensive air rights are in New York City were sold for $43 million, something to that extent. Now, I don't know if that's kind of what you're talking about. It's sort of how those are the projects that really excite me. I'm really glad you asked that because that's where it's no longer symbolic, right? So we're on the symbolic level, meaning like on the more performative make-believe would be someone like Carrie Young, the artist Carrie Young, British artist, who would draw a line on the wall, on the floor, and say, when you step into the square, well, it's in the article, right? You give up your constitutional rights. I mean, you have Guantanamo, so why would you even want to play with that? Yeah, with the rifle. Mm-hmm. And the other example, a bit more elongated, was Christophe Buchel. I can say that publicly now, not when it was happening, but he was in a legal dispute with the Mass MoCA over his copyright and moral rights to his installation. And his installation that never happened was called Training Ground for Democracy. But the lawsuit really became for him a training ground for democracy, where from the moment the legal dispute started on, that's when the project really began for him, because he started to see how even an art institution leverages the power of law against an artist. It was the very first time that an art institution sues an artist for the right to show his work without his consent.
Thank you so much for your talk. I had a comment for, I think the idea of art as fiction is perhaps our reality, but I also have this idea that art as nonfiction is perhaps an ideal, right? I mean, and I'm thinking about Max Weber's kind of ideal of value neutrality, even though he ends up...
Who was that?
Max Weber, the German
yes.
writer, who has this idea of value neutrality or facts, the possibility of facts as perhaps an impossibility, but an ideal nonetheless. And so when I saw your talk, this very provocative juxtaposition or maybe opposition between art and law, and forgive me if I read you incorrectly, but I read you as saying that art operates outside, has a possibility of operating outside the sphere of the reified structures of law currently as a language which perhaps is not teleologically oriented to tolerance and openness. But there, as a lawyer, is it not your task not only to interpret but also to bring about laws that are oriented towards these things, and we can point to major cases in the history of this country that have enabled those things. So, I'm just wondering what your stance on the possibility of this, or the use of this ideal and the possibility of an objective or positive law, and what that means for art, actually.
Sorry, I just remembered I got to get eggs on the way home. No, I'm kidding. It's a phenomenal question. I was writing down two things because I have to. That's going to expand my next talk. I can meet you halfway. Here's me talking like a lawyer on the fiction thing that you're talking about, because I also see from my students, my art students, they'll say something like everything is art. Right? Now, they're paying $45,000 a year to tell me that. Which my reply is, why the fuck are you here? Right? If anything is art, go to Wall Street, make millions, and call it art. Right? I mean, in its most perverse format, just go do that. And so I have to also think about this quote-unquote new phenomenon, which obviously is not new, called fake art. And so the question for us as artists is, where do we stand vis-a-vis fiction? But a good example of that is law, because the difference is that law does have force. It has a way of forcing you and me to do something or not do something. Art doesn't. And in this sense, it probably isn't a public good. So I want people who want to deal with law or language or power structures or physical power manifestations to really think about how they can make someone veer more to this way or that way, or as you said, in a more maybe hopeful, generous fashion rather than fascist. And the perfect example for that, on that note, I always think of Pasolini's Salo, 120 Days of Sodom, because that's exactly what happens when law becomes fiction, pure nothing fiction. It's suspended, but only so a new law comes in, right? And we all know, those of us that have seen that film, where that ends, right? The other thing about changing the law, it's an everyday affair. It isn't just with changing the laws. When I meet some adverse attorneys, I will literally sit across the table from them, and the first thing out of their mouths will be, "What the fuck do you want?" It's not good morning. It's not, what a nice tie. Where did you buy that? It's that, quote unquote, right? So that sets the tone. So then for me, it's how do I disarm them, right? So the law change starts from pedagogy. It starts from a personal interaction, because especially in what we do, the creative things like architecture and art, when you get to attorneys interested or in a because that's what law is in this country. It's been taught as adversarial. It's not how do we negotiate a problem, how do we problem solve, it's how do I beat you. And so we forget about, at the end of the day, there's an artwork, there's a building, right? There's a public space, there's a city that needs to be built. They don't care. And this is why this Buchel case that I mentioned, the Masmoka versus Christoph Buchel case, is very interesting, because at the end of the day, nothing was seen. Over $150,000 of public money was used, and the public got zero out of it. Is that? I'm not giving you guys like a lot of optimistic. Someone asked me something.
I would say you had a very interesting observation about volunteerism as a way to almost visualize what happens when law ends.
Oh.
I was just saying that Sergio had a very interesting observation about volunteerism as a way to talk about how law ends and the fiction involved, and I thought it was a hopefulness to it.
Well, she's my fiance, so she says it's interesting. She didn't think it was that interesting at 6 a.m. We participated in Thanksgiving morning in Austin, Texas, delivering meals to homeless individuals and anyone who needed a Thanksgiving meal. And on our drive to this volunteer organization, I thought, boy, it's just going to be a mess, right? And it was the complete opposite. Everything was functioning to a T. And I was, of course, thinking, why is this happening this way? It's because everybody that was there wanted to be there. Right? They had no, why would you give up Thursday morning, 6, 7, 8 o'clock in the morning? And so if they told someone, look, you grab a plate and you walk down the road and hand it off to somebody else, everybody did it. They were like little ants. It's because they wanted to be there. They weren't being told to do it.
Hi, I noticed that in your talk, you only used once the word justice, and it was not in relationship to law. You were just saying, like, you hoped to learn about justice going into law school. And so, and keeping in mind the slide you showed about the property law in the US and Native American territory, one cannot but think of the ongoing protests at Standing Rock and the sort of distance sometimes between what law is and what we might perceive as being just. And keeping that in mind, I'm wondering what you think the role of artists can play in this, in maybe almost being what you're talking about at the end, like being outlaws who can sort of push at this aporia that exists between law and justice.
Yeah. It's a great question also, because I think I deleted that section from this talk, but I often wonder, why is it always the evil people that get to break contracts? Why is it always the others that breach contracts? And a student of mine asked me that in relation to Native American land, and I said, well, the problem with the treaties, it's like a contract. It's only as good as the other party is willing to abide by it. And one of the things that we learned, think about this in its macro stage in law school, was efficient breach. When is it more cost efficient to breach a contract than to abide by the contract? Right? Now think about that with a pipeline situation. It's exactly what's happening at a macro level. And so it's not about whether there is or isn't justice. This is probably the only time I will quote Derrida post-2000. But it's a beautiful saying. He would say, law is not justice. It is just that there be law. Right? And unfortunately, I think that's probably the only thing he got right. Thank you.